Good morning, everybody. I want to welcome all of you to the law school and to this morning's annual symposium, which is put on by our Journal of Civil Rights and Social Justice. I can promise you that the symposium this morning will live up to its promise. It will focus on, obviously, child welfare issues, but truly emerging issues in the law. As you know, the first panel this morning, I think, will start us off with the most distressing and disturbing aspect of child welfare, namely abuse and neglect. And after that, we're moving probably into one of the most frontier areas of the law, LGBT parenting, which raises all kinds of novel issues, including the question of what even is a parent. And many different areas of law currently struggle with this particular question. Lunchtime, we're delighted to have a judge and members of the bar with us to talk about some of the practical issues that they now see emerging in the child advocacy area. And the afternoon panel will focus on immigration-related issues, unaccompanied minors, and their detention and ways in which we can avoid and mitigate those types of problems. So you're in for an exciting day, I think, of really thinking about some of the frontier questions that the legal system is currently facing. Now, it gives me really particular delight to see so many members of our community in the audience, students, and also many practitioners. We have a very diverse group of panelists, and I think this is very exciting because it makes it a truly interdisciplinary conference. We have legal academics and non-legal academics, practicing lawyers, a judge, and we also see, I think, a lot of people from the non-legal sector who bring their knowledge from different disciplines into this area. Government attorneys, and especially a number of activist organizations, which we're very excited about coming here together to really think about how to move this area of the law forward in the right direction. Now, how did we get here? I asked Dean Helwig this question, and I was delighted to hear that it was really one of, at that point, the director of CASA, Paul Quadrigium, now our current board member, raised this issue with Dean Helwig, and she was delighted to discuss it and approached Professor Shaughnessy to see whether we couldn't do something at the law school to discuss it. And Professor Shaughnessy, in turn, went to Professor Massey, and who is the advisor to the journal. What a fortunate confluence of circumstances. And as I understand it, the journal was absolutely delighted to turn its attention to an important question of social justice and civil rights. Now, there are always a number of people who make this event possible, and I've already mentioned a few of them. But I would be remiss if I didn't single out the entire journal staff. David Knuspel is editor-in-chief, and as I was told, especially Dominique Taylor, who did an incredible job under quite a bit of pressure dealing with 1,000 details in putting together today's symposium. So we're absolutely delighted about that. I know that Lee Kirchner, the administrative assistant to the journal, also truly did her work by helping with a lot of the details that come up in conjunction with putting on a successful conference. I should also mention today's sponsors of the event, which include the Shepherd Center for Poverty and Human Capabilities, represented by its director, Howard Pickett, here this morning, the Lewis Law Center, and also famous Bardeview are among the sponsors of today's event. I now want to introduce Professor Shaughnessy, to whom we owe really a lot of credit and gratitude for being here this morning. Professor Shaughnessy is the Roger Group Professor of Law at Washington at the Law School, and she's also a core faculty member of the Shepherd Poverty Program. She is well known, I believe, among all of our students for being quite challenging, but also incredibly caring. She teaches civil procedure, which I think by definition is challenging, professional responsibility, but I think to some extent her true love is in her seminar, in which she focuses on issues of child abuse and neglect. It's an interdisciplinary seminar, and it's also open to undergraduate students and law students. Now, her interest to children's issues goes back quite a while to her days in New York when she was a corporate lawyer. And she then began to volunteer with CASA, so a long-standing relationship with that organization. And I think that furthered really her commitment to child advocacy, and ultimately that's to her teaching in this area. So, to make the short of it, without Professor Shaughnessy, we would not all be in this room this morning thinking about the future of child welfare. It is her interdisciplinary approach and her interest in both academia and the practice of law that have made this the conference that it is. Please help me to welcome Professor Shaughnessy.
Thank you, Jean. Thanks to everybody who's here. Thanks to all our participants, many of whom came from far away to participate in this seminar. I want to also thank our sponsors, and particularly Lee Kirchner, Assistant Organizer Extraordinaire, and Journal Symposium Editor Dominic Taylor, who did the work of 5 people to get ready for this. Child maltreatment is a serious national problem. One recent nationwide study found that nearly 3 million children, or 1 in 25, were maltreated during the study year. Child maltreatment takes an enormous toll. Over 1,500 children die each year due to maltreatment by a conservative estimate. It may be much higher. Those who survive face possible lifelong health consequences, increased risk of a range of problems from heart disease, liver disease, substance abuse, STDs. One recent study estimated that the total lifetime economic cost of the child maltreatment that occurred in the U.S. over a single year was $124 billion by the most conservative estimate of maltreatment rates. Under a more expansive yearly estimate of maltreatment rates, the lifetime cost rose to $585 billion. So by any measure, this is a problem that we need to fight to solve. Some populations are particularly vulnerable to child maltreatment, and others face particular problems once they become involved in the child protective system. And those populations are the focus of the panels today, which Dean Leitner has already described for you. So with no further ado, let me turn the podium over to our moderator, my colleague in the Shepherd program, Professor Howard Pickard.
Good morning. I think that we all face a kind of somewhat difficult emotional situation right now. We're delighted to be here. I'm honored to be here introducing these wonderful speakers. And yet, while we're delighted to be here and to think together, we're also always aware that we're not delighted that we have to be here to talk about this subject. So I am, again, Howard Pickett from the Shepherd Poverty Program, and I'm honored to introduce today's speakers. The issue on the table for this first panel is, as the title indicates in your program, the boundaries of abuse and neglect. It won't simply be a discussion of abusive or neglectful or negligent parents. Instead, it might start to move into questions of how we establish whether someone is actually abusive or negligent, especially if they have, for whatever reason, limitations in realizing their own desires and plans for their children. There will be 3 speakers, and I will not waste any more time. I will instead direct your attention to their biographies as they appear in the program. Let me tell you the order in which we will proceed. I have the honor of reintroducing Sean Shaughnessy to get us started. Professor Shaughnessy, as you know, is professor here at WNL in the School of Law. Following her will be Professor Ann Massey, also... Oh, forgive me. Second will be Jessica Weaver of Southern Methodist University School of Law. And then finally, Professor Ann Massey of Washington and Lee. But up first, please, Professor Joan Shaughnessy.
Hello again. My topic today is the relationship between poverty and child neglect and the ambivalent legal response to that connection. A number of studies have shown that there's a strong correlation between poverty and neglect. For example, the most recent national incidence study found that children from low socioeconomic families had a 7 times greater likelihood of neglect than other children. I wanted to start with a story, one that was told brilliantly last December by New York Times reporter Andrea Elliott in a 5-part series. Both Jessica and I are going to be drawing on this story in our presentations, and I'm betting there's a Pulitzer in the future. Be that as it may, I recommend this series. Here is how Elliott begins. Quote, "She wakes to the sound of breathing. The smaller children lay tangled beside her, their chests rising and falling under winter coats and wool blankets. A few feet away, their mother and father sleep near the mop bucket that serves as their toilet. 2 other children share a mattress by the rotting wall where the mice live, opposite the baby, whose crib is warmed by a hairdryer perched on a milk crate. Dasani," and this is Dasani's family lives in the Auburn Family Residences, a decrepit city-run shelter for the homeless. It's a place where mold creeps up the walls and roaches swarm, where feces and vomit plug communal toilets, where sexual predators have roamed, and small children stand guard for their single mothers outside filthy showers. In the course of the series, we learn that 11-year-old Dasani, her 7 younger siblings, and her parents have been living in one room for nearly 3 years. The children sometimes arrive at school so hungry they cannot concentrate on their schoolwork. In the mornings before she leaves for school, Dasani changes and dresses her baby sister and helps her younger siblings get ready to go to school themselves. As a result, Dasani is frequently late to school. Her uniforms are too stained and dirty to wear from time to time, and she has to make do with donated clothing. On the weekend, she and her siblings search the trash for cans and bottles that can be redeemed for cash. Homework is a struggle. There aren't any desks or chairs in the family's room. The family isn't utterly destitute. They receive food stamps and some survivor benefits because Dasani's father is a widower. The shelter provides some meals, and it doesn't charge the family. Nevertheless, the family falls far below the official poverty threshold for a family of 10. But by supplemental measures, their situation is somewhat less dire, close to the threshold for poverty of their family. Ironically, because this horrible shelter is expensive to run and costs the state about $3,000 a month to shelter this family. Dasani is far from alone. Child poverty has been increasing in the United States. According to the Census Bureau, in 2012, almost 22% of American children were living in poverty, and 24% of children under 6 were living in poverty. Of these, 40% were living in severe poverty. Over 10% of American children are food insecure, according to the Department of Agriculture, and 1% were living with severe food insecurity. Over the course of a year, it's been estimated that 1.6 million children go homeless, at least for some period of time. So I think it's safe to say that Dasani and her siblings, like millions of other American children, are poor. But are they neglected? And if they are, what, if anything, should the government in general, and child protection in particular, do about their situation. On some understandings of neglect, Dasani and her siblings are clearly, obviously neglected. We define neglect as the concept that one or more of the child's basic needs, food, shelter, clothing, safety, healthcare, education, are not being met. And as a result, the child suffers harm or is at a risk of harm, then surely Dasani's situation meets this definition. The shelter is not safe. The residents are at risk of criminal assault. Dasani's own mother was sexually assaulted by a caseworker. Shelter has no certificate of occupancy. Fire is a serious risk. The children are exposed to serious health problems at the shelter. It's contaminated by lead, asbestos, mold, vermin. 2 of Dasani's siblings have asthma. Dasani's education is suffering because of her homelessness and hunger. Her grades decline as she stays in the shelter. So Dasani's basic needs are clearly not being met. She is suffering harm. She is exposed to the risk of even greater harm. So if we define neglect by looking at the effects of care deficits on the child, neglect is clearly present here. Under the effect of the child definition, the correlation of poor and neglected children will inevitably, I think, be very high. Not all children in low-income families meet this definition of neglect. Some families, because of particularly strong communities or because of relatively short periods of low income, are able to meet their children's needs and protect their children from harm or the risk of harm. But many other families, especially families in communities of protracted severe poverty, find it nearly impossible to avoid harm to children whose basic needs cannot be met. There is another approach to defining blameworthiness of the parent, one that is probably more prevalent when we look at the legal response to children in Dasani's situation. And that is to ask whether the parent can be faulted or blamed for failing to meet the child's needs. Whether Dasani's parents are responsible for neglect is a more difficult question than whether Dasani is facing the risk of harm or is being harmed by her circumstances. They might be faulted for not taking advantage of all available sources of assistance. There is no open public assistance case because Dasani's father had failed to appear for certain job placement programs. Neither parent is currently working, and they might be faulted for that. They might also be faulted for drug dependence. They're on methadone and occasionally use other opiates. Their drug use partly explains a lethargy that leaves Dasani responsible for caring for her siblings. The parents don't do a great job of managing the resources they do have. They spend resources at the beginning of the month, and there's nothing there by the end. So it certainly could be argued that Dasani's parents are partly responsible for the neglect of Dasani and her siblings. On the other hand, Dasani's parents seem to genuinely care for the children. When the survivor benefit check comes in, her father spends much of it on new boots for all of the children. The parents manage to scrape together $75 so that Dasani can take a field trip to Washington, D.C., something she had had her heart set on. Her mother traveled across much of New York City to give Dasani a chance to try out for an athletic team. So the picture is one of parents struggling against great odds to care for their children and often failing, sometimes but not always because of their own shortcomings. In truth, for families in poverty, like Tasani's, the cause of child neglect is likely to be a complex combination of factors involving the interplay between the children, the parents, the immediate environment, and the larger political community. The question of how we define neglect permeates the legal system's response to the problem. Some states have statutory definitions of neglect that focus on the harm to the child. Hawaii is an example. But other states, probably the majority of states, focus on parental responsibility in their definitions of neglect. Many explicitly exclude from neglect problems caused by poverty alone. And these definitions play a significant role in guiding decisions by child protective service workers and judges on whether intervention is warranted in the form of provision of protective services, removal of the children to out-of-home care, or ultimately termination of parental rights. I think the different definitions represent a deep ambivalence on the part of both our child welfare system and our legal system to this problem. On the one hand, interference with families is a serious step which causes great trauma both to the parents and to the children. Child removal, in the words of Justice Stewart, works a unique kind of deprivation. Government deprivations of a similar gravity are ordinarily accompanied by a showing of fault on the part of the defendant. And child removal, inevitably, however we label it, has a punitive aspect and a punitive feel. And it's difficult to justify punishment for circumstances beyond the control of the defendant. On the other hand, the overarching purpose of child welfare is, after all, child protection. And children can suffer real harm from desperate living conditions, even if the conditions are no fault at all of their parents. The pressure to ensure child safety pushes the system to approve removals, and once a child is in out-of-home care, pressure for permanency will combine with safety concerns to justify the termination of parental rights, even where it's not clear that the parents had any realistic ability to avoid the outcome given their resources. So part of the difficulty in formulating the best response to these cases is found in this ambivalence. And I think what you see often in the cases that actually reach the appellate courts is a description of a case, much like Dasani's, where much of the problem is due to lack of resources, but there is some additional parental fault, some failure to complete a treatment plan, fail to cooperate. That kind of additional problem allows the courts to find statutory grounds for removal and termination. How can and should we respond to these cases of poverty-driven neglect? Certainly, they can't be ignored. Studies using a range of definitions and approaches have found that neglect is the most common form of child maltreatment, and that it can be at least as damaging, perhaps more damaging, than other forms of child maltreatment. It poses problems for the child's physical, cognitive, social, and emotional development. So does poverty. In fact, poor children and neglected children are at similar risk of bad outcomes in similar ways. And the risk seems to be even greater when poverty and neglect coexist. Certainly, Child Protective Services works hard to respond to these kinds of cases. And the Auburn Family Shelter Child Protective Services, ACS in New York, was a major presence trying to monitor the at-risk families and provide services which might protect the children from harm. Indeed, in Jasani's case, ACS removed Jasani's mother from the family's room for a year and left the children alone with their father during that time. But it's not particularly clear that this involvement was helpful to the children or to the family. It disturbed the family. It troubled the children. And the article shows a pattern I think is very clear across Child Protective Services in many cases. It showed a deep and pervasive mistrust of Child Protective Services that's been found in many communities. The fear of losing custody of their children makes it very difficult for parents to regard Child Protective Services and the services it might offer as a source of genuine help and support. The children pick up on their parents' fear, and Child Protective Services becomes a source of yet one more stress on already stressed children. Outside help and support can make a real difference. In Dasani's case, it didn't seem to come from the caseworkers in the shelter. It seemed to come from the schools. But the schools can't do it all. They can't be the only source of help and support. I'm going to mention a few things that have been tried that seem to have some promise, and Jessica will pick up and talk more about how these problems and these cases might be approached. One possibility is to try and make Child Protective Services intervention less adversarial. And Virginia has taken that approach. Instead of having report investigation, adversarial investigation, Virginia, for many cases, has another tract, the Family Assessment Tract, which is actually used for most interventions here. And I will be interested to hear from some in the audience how effective they think that movement toward differential, non-adversarial response has been. Another promising approach is to try and intervene early outside the Child Protective Services setting through things like nurse home visits for new mothers. The argument there is that this is a time when parents are receptive to help, and the help is not the accusatory help that can sometimes seem to be the case in more traditional child protection. Other early intervention techniques work with families in groups on parental education, also show a great deal of promise. But I think what the research really shows is that if we have any hope of intervening, we need early, sustained, intensive, supportive intervention. And it's hard to get. The battle just to have 4-year-olds have universal pre-kindergarten is far from a done deal nationally, much less having a system that provides the supports families need from birth forward. But we remember what the true cost of child maltreatment is, we may be more likely to be willing to invest the resources it will take in intervening in this terrible cycle. In fairness to the city, I have to tell you that Jasani's family, at the end of the article, does move out of the shelter into an apartment, but it took a baby's death in a room down the hall to make that happen. Mayor de Blasio announced last week that he was moving all the children out of the Auburn Family Shelter. So you'll be pleased to hear that news as well. With that, I'll turn it over to Jessica.
Good morning. Hi, everyone. I'm really happy to be here. My name is Jessica Dixon Weaver, and I'm from Dallas, Texas, Southern Methodist University Dedman School of Law. And I first want to thank Professor Shaughnessy for inviting me to Washington and Lee to give this presentation. When I first entered the Legal Academy, I came here for a junior faculty workshop, and Professor Shaughnessy has been a mentor of mine since that time. So I'm very happy to be back. And I am actually going to pick up where she left off and talk a little bit about theories on child homelessness and poverty. She and I actually talked earlier this week and realized that, oh, we're presenting on the same thing. So I actually think about this in a larger perspective, primarily because of my background. I was a former guardian attorney at Litem for Children in the child welfare system, and then I was director of the child advocacy clinic at SMU. And so I've had a long time to think about and observe how children and families in the system fare as time goes on. So my presentation today explores theories on poverty, specifically focusing on our society's responses to child homelessness. Professor Shaughnessy mentioned that there's often an ambivalent response to what is chronic, persistent poverty. And so in thinking about the types of neglect that Professor Shaughnessy outlined, I also want to touch upon a particular type of neglect that I have written about in the past, which is psychological abuse and neglect. I want to sort of position this psychological neglect of children by parents alongside the duty or obligation that we have as a society and that the law has towards the well-being of children. Though poverty is not a reason to remove a child in most states, it is a risk factor in child welfare cases, and it is also a cause for concern in our country. In a previous article, the principle of subsidiarity applied, reforming the legal framework to capture the psychological abuse of children, I suggested that the primary consideration of child welfare courts should change. Currently, the primary overarching consideration of family courts and juvenile courts is the best interest of the child. I argue in that article that the primary consideration of courts should be strengthening the family unit to better serve the child, because oftentimes professionals like to separate what is in the child's best interest from the parent or caregiver who caused the child to be removed in the first place. After years of experience, it struck me that when social services and the courts are making what they're required to do, which is reasonable efforts to maintain the child in the home and to keep the child with the family, it would be best to focus on strengthening the family unit so that it can be the best environment for the child. This should also be the overarching goal for those who seek to address this growing issue of homelessness in the field of child welfare. There we go. All right, so there is a context that I'd like to look at this issue in. This is not the first time that our country has faced a large percentage of family and child homelessness. Between mid-1800s through the 1930s, we had what was considered to be an epidemic with regard to child homelessness. And the first picture is a picture of kids during the Great Depression, which was part of that time. And the second picture is a picture of the orphan trains, which was a movement that began by a young minister, Charles Loring Brace. And he believed that the hopeless plight of children could be solved by removing them from the city and placing them with good moral families in the Midwest on farms. And so at the time in New York, there were 30,000 children who were homeless in the streets of New York. And these were mostly the children of poor parents, poor immigrant parents, And as the laws in our country changed with regard to immigration, there were more people who came, more children who came with them, and greater issues with regard to poverty among families. So these parents were not necessarily wanting to be parted from their children, but they basically surrendered their children in an effort to ensure their survival. And Minister Brace actually started an organization called the Children's Aid Society, and this was the organization that actually went to the parents, sought their sort of termination, as you will, or relinquishment, and then placed the family. So it was not a state-run situation. It was a private-run group that really advertised in papers amongst people who had gone and moved out to the Midwest if they wanted to adopt or have a child placed with them. Usually in this situation, not only were kids removed from their parents or separated from their parents, they were also separated from their siblings. And so some of them found loving homes, and they were much better off than they were in the streets in New York or in orphanage or military schools, which were the norms at the time. But other children were used as cheap labor because these were farms that were being settled. And so even though they weren't indentured servants or slaves, many of the children who are still alive, there's a documentary that where many of them are interviewed, recount that they were treated as such. Even when they were selected, they were looked at as in a row as if they were slaves. So they were definitely treated like property in this situation. Some refer to this orphan train movement as the beginning stages of our foster care or modern day foster care system. It also was sort of the beginning of efforts to try to deal with child labor laws or to establish child labor laws and also child protection laws. As you would imagine, some of the families were not properly screened, and so abuse did occur with some of the children. This movement lasted a really long time, 75 years, and between 120,000 and 250,000 children were relocated to these farms. So again, you know, we see that New York City is now the center of an issue of homelessness with Dasani's case. In this respect, there's a change as far as who the children are. So the biggest issue that we deal with regard to homelessness now is the Great Recession, which has caused a great deal of families to lose their homes. And it also highlights the issue of race, because there's a disproportionate number of minority families who are homeless. 51% of the children in shelters under age 6 are African American. And there's a large number of both Hispanic and Native American children in states where there's a larger percentage of those minorities. Most of the women are single, and they have young children. Usually domestic violence might be a factor in the reason that they're homeless. As Professor Shaughnessy indicated before, similar to Jasani's parents, there's low education of job skills, and substance abuse is often an issue there. So this is a picture of a child in actually Dallas, Texas, in a shelter, and it's a picture in a shelter of women and children eating. So you can sort of see the different groups of mostly all women. But there are families like Dasani's that are intact that are homeless, but the highest number are single women. So going back to what I mentioned earlier about psychological neglect, Professor Shaughnessy mentioned neglect and how it relates to homeless children. And in highlighting sort of the emotional issues that children deal with, research shows that they experience complex trauma. And so this results in chronic stress and anxiety for them, which all obviously would affect them in school. And as they grow up, they also experience depression and PTSD. There's a high exposure to interpersonal and chronic community violence. One of the things that was particularly insightful to me as I was researching was that 46% of the women who are homeless, at least in one particular study, had experienced sexual assault before the age of 12. And then after that time, they experienced another sexual assault after they reach the age of majority. And so when we think about the type of violence that these children are exposed to, much of it is of sexual in nature, and in many instances, there are women who are being assaulted in the shelters and also within their communities. We know that there's inadequate services since the recession. There's been cuts to most state and local child protective services, as well as reductions in the amount of giving that goes on with regard to private charities. And there are also barriers to access. So one thing we know from the child welfare system, about the evolution of it and the positive changes is that we have child advocacy centers where families and children can get everything in one place. Well, we know that the services that are offered to homeless families are not in one place. They have to go all across the city to get to it, and that's highlighted in Dasani's case where her mother has to get on the train with her children to go different places or get a cab. And some of the barriers are simple, like transportation and money to have, to get to these places where they can access the services they need for their families. Essentially, we have negative outcomes in a cycle of poverty. Many of the parents of the children who are homeless were also poor, also have issues with regard to complex trauma that was never treated, and so the cycle continues as in many instances drug abuse or substance abuse is a way to treat some of the stress and disorders that they're having. So there's an article by Barbara Stark, who's a professor at Hofstra, entitled Theories of Poverty, the Poverty of Theory. And so one of the things that I looked at when I reviewed her article was, how did poverty come to be? What is the state's obligation to poor people? And what is society's obligation to the poor? And so she highlights 3 to 4 different theorists with regard to poverty. Immanuel Kant, who basically sets forth that poverty is sort of inevitable, that the state really has no obligation to help, and it's really individuals who have a moral responsibility, although it's a voluntary one, to help. He basically says, there's a moral duty to help alleviate poverty. We hope other people would do the same for us. So, but for the grace of God go I type of outlook with regard to why we should give individually to the poor. The moral argument is compelling or appealing because it's not coercive, and the benefactor is sort of the virtuous person, whereas the recipients are the unfortunates. In this, or in his theory, there is a differentiation between the unfortunate poor and the undeserved or undeserving poor, whose poverty is their own fault. And we see that in our society in responses to homelessness, and even Dasani's story about the substance abuse of the parents. When they weren't substance abusers, they could provide for their families and they should be working. So there's a instance where we sympathize and support hardworking, self-sacrificing, and sort of down on your luck poor, but we also judge persons who we think are lazy, dishonest, self-indulgent, willfully ignorant poor, and so those people must deal with the consequences of their own bad choices. And I just want to say here that, part of the differentiation between the undeserving poor and the unfortunate poor is driven by both social constructs such as race and also politicians. If you all remember Ronald Reagan, setting forth the welfare queen as sort of a mantra of why there shouldn't be welfare and entitlements. And that person was a black female, a single black female mother. And so even though there weren't a lot of statistics that said that welfare fraud was rampant, that was sort of the picture that was set forth. And so that dictated what many people saw as, the undeserving poor, and why welfare should be eliminated or at least limited. So that's something that to keep in mind with regard to when we think about people and their willingness to give or to see the poor in a good light. Payne and Rousseau, in her article, talk about, or Thomas Paine believes that poverty is a result of injustice. And so, we have an elite that has property, that has sort of disenfranchised persons who, poor persons who don't have property. And so poor people should have, or do have, rights to demand fairness from the state, and that individuals will, be concerned about collective well-being as far as the reason why we should be concerned. Jerry Bentham, in her article, talks about poverty being painful for all of us, the people who are poor and also the people who aren't poor. And he directly says that poverty should be addressed by the state, and that society should reorganize our legal and economic institutions in a sensible way. And so looking at how we set up our institutions in order to deal with poverty is a main issue. With these as a backdrop, I looked at the principle of subsidiarity applied to poverty, which is the principle that I used in my previous article about psychological neglect, which is, and the principle of subsidiarity basically is that it suggests that people who are closest to the bottom or to the problem at hand are the ones who have the strongest moral claim to finding the solution. And so it sets forth that a matter should be handled by the smallest or least centralized competent authority. And the word is actually derived from a Latin word, subsidium, meaning to help or to aid. And sort of the opposite of the bottom up is the top down, which is similar to what we have in our country, where there's a centralized government that sort of hands out welfare checks, money, rather than doing other things that could be done on the bottom level with regard to dealing with this issue of poor people. Part of this principle sets forth that if you empower higher authorities to, as anything, it endangers the rights and liberties of those who are most affected. And so it embodies this practical point that the ones that are closest to the problem have the strongest interest in seeing the problem solved most competently. And when I think about this, I remember there's a film that I think some students at NYU captured of parents who are in the child welfare system, and they talk about, who are mostly minority parents, their children being removed for, in many cases, false reasons or reasons that were not substantiated. And one of the parents made the comment, if they would just come and speak to us and talk with us, we could tell them, what the issues are in our communities and what the needs are for our children and our families. But the impression that they give is that, CPS, as Professor Shaughnessy said, is to be feared, and it's sort of this higher power up here that comes and swoops in and removes children from their homes without really consulting with them or meeting them at their level. So as I looked at how it would apply to poverty, Professor Shaughnessy mentioned some of the solutions that are being used now for child homelessness, and we do have a lot of, and I'm sorry for all the different lines, I'm not that skilled with PowerPoint to sort of make all that work, but it should be actually TANF and SSD with a line from the federal intervention to the state intervention. But on the federal side, there are some new projects that have come forth since President Obama has been elected. Open Doors is one of them, which is was presented, I believe, in 2010. It's its federal collaborative effort to eliminate homelessness within a certain time frame. And so it also sort of dovetails with the campaign to end child homelessness. And then the National Center on Family Homelessness has set forth Be Safe, which stands for Building on Strengths and Advocating for Family Empowerment. And so within that particular program, there's a push for rapidly rehousing families. So instead of them being in shelters like in New York, pushing them to have to get vouchers quickly and get into apartments where they are in single homes and they're not living in a group situation. It also emphasizes linking housing with services. So recognizing that housing, while it is an important situation for people who are homeless, is not the only thing that they're dealing with. Again, going back to the complex trauma, they also need services for their children and services for themselves. And so it emphasizes sort of creation of individualized services of a high quality, and also emphasizes a basic standard of care training for the people who are offering the services to them. So being able to train the people who are dealing with them who may not come from their communities to offer the services so that they can relate to them and not have sort of this issue of fear and mistrust. In the previous article, I talked about, with regard to psychological neglect, that schools and health clinics were really on the front lines of child neglect and abuse, and they're the doctors and nurses and teachers are the ones that really see those kids firsthand, and that in fact most families trust those people with their children. They see them more often. The schools, obviously, they see them daily, and medical clinics, they go to them more often than they would see Child Protective Services. So in that article, I argue that those are the institutions where social workers should monitor children, whether it's a differential sort of non-intervention method where it's prior to litigation being filed or afterwards, that it's best to have those relationships from the people in the community. And in this instance with poverty, I think there are a couple of things that I want to highlight with regard to what could be done with communities. And so with regard to subsidiarity, the churches and CDC stands for Community Development Corporations, which oftentimes are started by places of faith, and they're used to sort of create social and economic empowerment in neighborhoods that typically have been neglected in cities. And so these two things, or two entities, or two institutions could provide valuable resources that the child welfare field is really running short on. Because of the recession, because of cuts in local counties and states, they don't have enough service workers or services for children and families. The other thing that we have in community with regard to intervention are community clinics and centers, and that would be health clinics as well. With regard to state intervention, we know that child welfare does enter into the picture in some instances with poverty and homelessness, and many of the parents are receiving welfare from TANF or Social Security disability benefits, as in the Dasani Coates case. So I'll end with this. So in looking at this whole situation, we know that child welfare, or the child welfare system, is really not enough to deal with this whole situation of poverty and homelessness, and it's something that needs to be dealt with more on the front end. And so to that effect, one of the things that the principle of subsidiarity talks about is that when we deal with things from a local level, we can be more creative about how we approach a problem. And so instead of having the government sort of set forth a 10-point plan, we can sit down and collaboratively come up with ideas about how to handle the situation. And so in many respects, families do need help at the smallest level, and in some instances that requires intimate contact and relationship building, which could be done through home sharing. And home sharing is a concept that I talk about in a forthcoming article with regard to sharing of child care and elder care, where older persons or single women take on boarders who are single families or single women with children to assist them with their finances, and they also share collaboratively in raising children and caring for each other. And so that's something that is being done in small neighborhoods around our country. It's more common in Europe, and sometimes it's done amongst elderly people together, home sharing, but it's a concept that should be considered in something that we could do with regard to screening and all of that from either a private charity situation or a combination of private charity and the government. The other thing I was thinking about was that we have situations where we foster a child, but in the home sharing situation you're fostering a family. And so you'd have one family helping out another family. So if you think about, this idea of private charity and people giving and having a moral responsibility to give, that this could be something that we could also institute from a community level. And then with the local government, just using creative ideas from the community, using community court systems, volunteer judges or community judges to handle some of the issues that come up instead of going to our formal legal system and creating sort of records for these families who really need help in raising their children, but they don't need sort of an intervention that causes friction and more added stress and anxiety to their families that's already there. So with that, I will end and pass it on to Professor Massey.
Good morning. I am talking about something very different from what we've been hearing about, and that is circumstances of medical neglect based on the parental objection to medical care due to their own religious beliefs. So I have a picture, it's kind of hard to look at, and I won't leave it up the whole time I'm talking. Oh, golly. This is Elena Weiland. She was born in December 2009 with an apparent strawberry birthmark over her left eye. But the mark started to grow rapidly, and by 7 months, it was a large hemangioma that the New York Times described as about the size of a baseball. She had pushed her left eye out of its socket and threatened her with blindness. This happened in Oregon City, Oregon. Her parents, Timothy and Rebecca Weiland, were members of the local Followers of Christ Church, which teaches faith healing instead of conventional medical care. So they had treated Elena with prayers and with anointing with oil and other religious rituals. But the hemangioma continued to grow. Anonymous reports came to the Oregon Department of Human Services, who took temporary custody of Elena. The department removed her from the home and placed her in foster care for 2 to 3 months. During that time, she was hospitalized for 6 days for intensive medical care. She remained in state custody but was given back to her parents, who agreed to follow medical advice, keep all doctor's appointments, and administer the prescribed medications. The case received national attention when the Clackamas County, Oregon prosecutor decided to bring charges against the parents for first-degree criminal mistreatment. After an hour's deliberation, the jury returned with a verdict of guilty. And the judge sentenced each of them to 90 days in jail, actually, to be served first by Timothy and then by Rebecca, so that there would be a parent available to take care of Elena. At age 18 months, she was reported to improve significantly, although the prosecutor summed up her condition as extremely unlikely to regain normal vision. Now, notably, Oregon prosecutors had complained about their inability to bring this kind of case after the discovery in 1998 that the graveyard of the Followers of Christ Church contained 78 children, at least 21 of whom could have survived with appropriate medical intervention. At that time, Oregon provided legal protection to parents who refused medical care for their children on religious grounds. In 1999, the year after the discovery of that graveyard, the Oregon legislature repealed that statute. Okay, I think we can turn that off. Thank you. The scenario of Elena Weiland presents us with several striking characteristics. Parents here objected to conventional medical care for a child based on their sincerely held religious beliefs. The child's life was not in danger in Elena's case. Yet the judge did order the medical care to be administered. And that order, in this case, was even followed by criminal prosecution and conviction. Neither the Child Protective Services nor the judge had any trouble overriding the parent's religiously based choice, even though the condition was not life-threatening, and the child posed no danger to other children. For example, if they had refused vaccinations for standard childhood diseases, and then she had attempted to enroll her in public school, that might pose a danger of measles and other conditions we're aware of. A great deal of ink has been spilled over the general question of how law should respond to conflicts between parental choices not to provide conventional medical care to children when that choice is grounded in religious belief, on the one hand, and on the other hand, the health and welfare of the children whose conditions are affected. The dilemma was exacerbated by the fact that between 1974 and 1983, Congress actually required in the Federal Child Abuse Prevention and Treatment Act, or CAPTA, Congress required that states receiving federal dollars for their child abuse and prevention programs must have these religious exemptions built into their medical neglect definitions. So until that time, only 11 states had such exemptions, but of course immediately all 50 states passed these statutes in order to get the federal dollars. That requirement was quietly listed in 1983, partly on the grounds that some Congress people thought that it was probably unconstitutional, as a violation actually of the First Amendment Establishment Clause, government favoring religion or certain religions over others or over non-religion. But CAPTA still provides that nothing in the Act should be construed as establishing a federal requirement that a parent or legal guardian must provide medical services in cases where that parent or legal guardian objects on religious grounds. So it's been left up to the states to decide whether to have religious exemptions or not when it comes to conventional medical care for children. 43 states, including Virginia, still have the religious exemption laws. Although a state senator in the state of Washington recently introduced a bill that would repeal that state's religious exemption law, and Idaho has at least given some consideration to a similar step. Now, all of these laws, including Virginia's, do permit a court to intervene when a child's life or welfare is at stake. The most common example is judges ordering blood transfusions for children whose parents object to that form of medical care, and the child's life is at stake. Now, what happens here is the judges usually look at the parents' rights to bring up and educate their children as they see fit, which of course includes the rights to train their children in the religious beliefs of the parents. And they pair that with the parents' First Amendment rights of free exercise of religion. And they see those two together as persuasive justifications that conventional medical care should not be ordered for children who may be in very dramatic situations, such as Elena's, but whose lives are not actually threatened. Only when the child's life is threatened are judges likely to step in. Now, before I start in on a real legal analysis of this problem, I do want to make it clear that I do not disrespect anyone's sincerely held religious beliefs. And I do not discount the numbers of stories that exist where people relate their own personal experiences of using prayer and religious means to overcome medical conditions, and where those have been successful. I don't discount that at all. I don't for a minute quarrel with an adult's decision to make those kinds of choices for the adult's medical welfare and to live or die with those choices. I do quarrel with deciding these things for children when we're talking about the adult's right, but it's the child's welfare that is being affected. And I say that where children are concerned, an adult's right, even a parent's right, to force a child to live or die by the adult's religious beliefs should not be tolerated by our laws or by our child welfare services or by our courts. The primary reason for the reluctance of courts to order medical care for children who may end up growing up with very dramatic effects. I mean, the way the courts look at it is, well, if the child's life is not threatened, the child can grow up and do something about this if the child wishes to. But you see, with a situation like the one of Elena Weiland and other situations, that can well be much less correctable by the time the child grows up. And in the meantime, the child must live with painful psychological and emotional consequences of the choice that's been made. Now, the primary reason for the reluctance of courts to order medical care in these situations is that even before the era of CAPTA was that it means overriding the rights of parents to bring up and educate children as the parents see fit. As long ago as two cases decided in 1923 and 1925, respectively, both dealing with education, the U.S. Supreme Court enunciated a basic right of parents to bring up and educate children as they see fit, including, of course, training them in their religious traditions. And that parental right is generally considered to be fundamental. That is, it is to be restricted or overridden only if there is what is called a compelling state interest at stake, and the means chosen to restrict that interest are narrowly tailored. Now, when a child's life is at stake, this is called in constitutional law strict scrutiny. When a child's life is at stake, a judge usually has no difficulty in saying, oh yes, we have a compelling interest in saving this child's life. And administering the life-giving care is a narrowly tailored means to fulfill that interest. But when we're talking about serious medical conditions that might be extremely debilitating, certainly while the child is growing up and maybe beyond, judges often say, no, we can't intervene at that point. So courts have generally followed, in other words, that same strict scrutiny to say that correcting non-life-threatening conditions does not pose a compelling state interest, and such that conventional medical care should be ordered. If the child wants the condition corrected when she grows up, she can see to it then. Obviously, she may be extremely damaged by that time. For example, in a case in New York called In Re Seifert, 1955, New York court dismissed a petition requiring surgery for a child with a severe cleft palate and hair lip. On the other hand, in 1972, the New York court did order surgery to correct a massive deformity on the right side of the child's face and neck, reasoning in part that the psychological damage to the child growing up with that condition would be irreversible. When CAPTA was amended in 1974 to require religious exemptions, that only exacerbated the situation. As I said, quietly lifted in 1983, didn't really publicize that, so the situation hasn't changed very much, but some courts are starting to. I maintain first that the state's interest in the child's welfare is always a compelling interest. It doesn't have to be life-threatening, and can justify mandatory treatment in serious cases. And secondly, and maybe more importantly, at least from the standpoint of legal analysis, I think we should look to the Equal Protection Clause in cases like this and look at how we are protecting the children with our laws, or not. Because after all, medical neglect and abuse laws, or medical neglect laws we're really talking about here, only apply in very rather extreme situations. We're not talking about a child with a common cold and the parents don't take the child to the doctor. In fact, medical neglect laws are precisely that point where it's deemed that the parents who owe their child certain needs that you've been hearing about, food, shelter, clothing, and adequate medical care, precisely where we think that the parents are failing, where parental rights leave off, and I would say the rights of the child, or society's right to see to it that the child's needs are met, begins. So medical neglect is itself a very high bar. We're talking about basic welfare of the child that we would recognize as being an example of medical neglect, at least if we were talking about other parents who did not have religiously based objections to the medical care. And so I would apply that same reasoning to cases where there is that kind of religiously based exemption. I think that all the purpose of the medical neglect laws is such that all children deserve the same degree of protection. Behavior that would constitute abuse or neglect of a child engaged in by one parent should apply equally to all parents. In fact, I would go further. I would say that the state, who is considered to be, or which is considered to be the ultimate parens patriae, the ultimate parent of all of its citizens, and particularly its most vulnerable citizens, its children, actually has a duty to see to it that these children are provided with appropriate medical care when it's a question of medical neglect. Now, the question I haven't particularly addressed is how to weigh the parents' First Amendment rights to free exercise of their religious beliefs, other than to say that obviously they have that right to exercise their religious beliefs as they see fit when it's their own health or welfare at stake. Now, the Supreme Court, looking at religious objections to various kinds of behavior and what free exercise means, has generally drawn a kind of belief-conduct distinction. And the jurisprudence says that a person has the right to believe anything the person chooses to believe. But when it comes to laws of general applicability, laws that apply to everyone, then the state has the right to apply those laws to everyone. And the only time when that might be trumped by free exercise rights will be when the law is specifically directed at a given religious practice or religious group or religious actor. Child abuse and neglect laws are not directed at religious groups or religious actors. Their aim, their purpose, is to protect children from a kind of abuse or neglect at the hands of their parents. Any exemption from the reach of such a law must necessarily be a matter of state statute. And even then, as I have said, not only the child's life, but also the child's welfare provides a valid grounds for state intervention. All of these laws provide that if the child's life or welfare is at stake, even these religious exemption laws, there may be an intervention. What this means, I think, for persons involved in child welfare, particularly those charged with responsibility for reporting suspected child abuse or neglect, is that they or anyone should be reporting these situations when they see them to appropriate authorities. And even if you know that the basis is religious belief, nonetheless, it's appropriate to report these situations. And child protective services, judges, courts, others charged with enforcing the law, I would say, should not hesitate to take steps to see that the requisite care is provided. Children are as entitled as anyone to the equal protection of the laws. In this case, protection from the consequences of the beliefs of their parents, when those consequences might mean debilitating, disfiguring, or damaging conditions that could haunt them for a lifetime. It is the rights of the children, I think, in these situations, and not their parents, that we should be concerned about. Thank you.
We have about 10 minutes for your questions. However, I may indulge in my privilege as moderator in asking the first. It looks to me as if the three papers are actually, one way to see them at least, is to see that what we've got is a conflict between two goods, or even more specifically, two essential capabilities for the children. On the one hand, there is some general range of capabilities, we might say a capability to have life, bodily integrity, health, on the one hand. That's compromised in all of these cases. And on the other hand, there's a capability of, drawing on what Professor Weaver has pointed our attention to, something we might want to think of as family affiliation capability, right? That in order to have a good life, I ought to have the capability of living with my family. In Professor Shaughnessy and Professor Weaver's papers, we saw a situation, and I'm oversimplifying, of course, a situation in which the tragic choice that a family is making between those two things is due to lack of resources. And those may be personal resources as well as material resources. In other words, in those cases, the family wants a good for the child that is basically in agreement with what the state generally wants for the child, what the community wants for the child. In Professor Massey's case, however, we enter into a much more problematic scenario in which what the family wants for the child, the conception of the good for the child, seems to be remarkably different from other people in the state's conception of the good for the child. Right? Their religious freedom and family affiliation trumps
Well, they still want
medical.
help for the child.
They still want help for the child, and they disagree over the means of achieving
That's
that.
the point they always make quite strongly.
Right.
Yeah, they want the child to get better.
Right. But they have a disagreement about the means of doing that. That's a good clarification. Let me focus in just on Professor Shaughnessy and Professor Weaver's papers with my question. It's this. I want to ask both a kind of empirical question and a normative question. On the empirical side, I'm wondering what do we know about the effectiveness of families in providing for the so-called basic needs of the children. In other words, when families who are under-resourced are supported through public or private means, are they better at generating long-term health and well-being for the children than the state would be? What do we know about that? And then beyond that, the normative question, should we conceive of family affiliation as one of the basic needs for the child? In other words, maybe we would think to ourselves, we want to address their health needs, but there would be a tragic choice between that and addressing their basic needs of living with and loving their families.
Maybe I'll talk a little bit about the second question. I think it's very clear that children need a family. The research about what happens to children who grow up without a family, in congregate care, alone as teenagers, aging out of foster care, the research about what happens to such children is graphic. What happens is awful. And I won't go into all the details, but that is very clear. It is not always clear that a child needs their birth family or needs to be housed with their birth family. So certainly, as Jessica said when she talked about the historic picture, there are children who move happily into new families. I think even in those cases, in many situations, the children are better off if they are able to maintain a connection with their birth families, even if those families cannot be brought to the place where they can care for the children full-time. Especially if the children leave their parents after infancy. And Jessica may want to take a stab at other things.
So for the first one, the effectiveness of providing the basic needs for the children, whether that generates better long-term health and well-being. I think that's the issue that comes up in much of the research that I found, that it wasn't just the housing that was the answer to the homelessness issue. It was the fact that, once single mothers do have housing and maybe they have job training, when they go to the job, maybe they have to work 2 jobs and they need someone who can care for the children. And so then you have the child care issue. So it's a multi-layered situation where the needs of the families can't be met without a proper support network. And so for the differences between the families who are still poor but not homeless, it's they're able to manage because of their support system within their family or support system within their community. So even if it's not family members, it might be people in the community, neighbors, it might be someone at their church or synagogue or whoever can help them with the small, intimate parts of their life that, the government can't necessarily step in and do. So while we have Head Start, and that's great, it's limited in how many families can actually take advantage of it, and it's not there for after hours. It's not there for when children get sick, small children, many of these women have small children and they can't go to daycare because they have a fever. They have to stay out for 24 hours, as many of you older parents know, before they can go back, and so then they have to take off time from the job and they lose the job. So there's a cycle of situations that occur when they don't have the proper support network. They can't actually lift themselves out of poverty. And so while they might have the housing, it's very difficult to move to the next level. Then the other thing I think that we see something in our current political climate that's being talked about is raising the minimum wage. And so for those who are the working poor, even if they do have a job or 2, depending on how many children they have or what city they're in, they're still unable to really effectively provide for all the basics for their children. So sometimes having to choose between, medicine for a child or a pair of shoes, or, in Basani's case, sacrificing for a trip to Washington, D.C. to expose their child to something so that their child can have dreams and hopes that they don't have versus, basic needs. And so I think there has to be more that both communities and government can do, but it would really take a collaboration. I think the Open Doors program was great because it included people who were homeless in the conversation, so it wasn't just sort of a top-down, here's what we think should happen. It was at least conceivably a bottom up, or from the bottom up, including all different levels of partnership. So, I mean, I think that we have to conceive of different ways in which our welfare system, both from a financial standpoint and also a service standpoint, can help families in perhaps unconventional ways, but when we think about our own families and how they survive, they're what all families need, is help with kids and help on the weekends and things of that nature. The second question, I think, Professor Shaughnessy, covered, I think family affiliation, obviously we know from the orphan trainings that separating those kids from their families was sometimes a good thing, sometimes a bad thing, but one thing that's true of what those interviewees said, which is also true of children who are adopted, is that they often fill a void, in their soul as far as who am I, who are my parents, where are they, and they are always seeking that. And so to the extent that we can keep families together, I think it's important. I think the UN Convention on the Rights of the Child has that as part of an article, that the child has a basic right to be with the family, and it's a reciprocal right, and in some ways our family laws in the United States do afford that for families, that children have a right to be with their parents as much as the parents have a right to raise their children as they see fit. But it really depends on sort of how our central authorities view when it's proper to come in and remove children, and then you actually cut that tie. So
I know there's going to be a lot of opportunity throughout the day to continue these conversations in private and in smaller groups. Please join me in thanking our presenters.